Okay, everybody. This unit is going to be going over the judicial branch, and in my mind, there are three big concepts. One of which is going to be covering the meat and the potatoes of the court system. What does the judicial branch look like? The second main concept is going to be your First Amendment rights. Again, RAPS: religion, assembly, petition, press, and speech. Our third main concept is going to be the rights of the accused, the Fourth, Fifth, Sixth, and Eighth Amendment. Each one of those concepts I'm going to try to split into two separate PowerPoints for each topic to make them a little bit more compact. So let's take a peek at what the judicial branch looks like. In accordance to federalism, we have what we call a dual court system. Remember, federalism is national government, half state government. So let's take a peek at the federal courts. Again, federal crimes that are a violation of congressional law. And again, I always draw that line of being sarcastic about somebody steals my dog and crosses state lines. Again, state lines is the concept there. We have 94 federal district courts. You're guaranteed of at least one district court per state. This is where the courts hear evidence and you can confront your accusers. The next level, if you don't like the decision, you can appeal your decision to the appellate court. And there are 12 regional courts. And the final system in our federal court system is the Supreme Court. Altogether, there's about 1,700 judges when you count all the judges on all three levels. Again, the president selects all 1,700 of these, or at least the vacancies in those 1,700. We always focus on the Supreme Court judges that the president gets to select, but in theory, he appoints any vacancies of those 1,700 judges. But again, this is the dual court system. We talked about the federal court. Let's take a peek at the state courts. That's when you break a state law. Considering we have 50 states, and many states have different laws, most of the cases are heard at this level, because there are many more of them, obviously. In Illinois, at least, we have 22 circuit courts, which is basically the same thing as the district courts in the federal part. Every court case starts at the circuit court. Then there are appellate courts and one state Supreme Court. One difference between Illinois and the federal court systems: in Illinois, all the judges are elected. One other thing about the different court systems that I'm describing right here, what I don't think is necessary for you to remember is the number next to these courts. I want you to know the concepts of what goes on. I'm not going to try to trip you up with 22 or 5 or 1. There are two types of cases that we're going to be looking at as well. Criminal cases are heard in criminal courts. Clearly, it's going to be murder and burglary, as well as shoplifting, kidnapping, rape, arson, and assault. Another type of cases are civil cases. Those are cases that don't break the law so much, but there are punitive damages. So breach of contract, maybe landlord or tenant agreements. If I hired somebody to build a fence around my yard, but he accidentally built it 6 inches onto my neighbor's land, and I called him back to have him fix it, and he refuses, I'll have to take him to civil court to have them fix it. Debt collection, divorce, maybe even foreclosures are all in civil courts. There are two types of crime. Obviously, misdemeanors are not going to be as serious. There's going to be like petty theft, maybe public intoxication, trespassing, and simple assault. The next phase is felony. They are very serious charges. It's going to be more murder, burglary, rape, robbery, possession of drugs with intent to distribute, stalking, those are very, very serious crimes. We're going to shift gear fairly quickly right here and talk about the federal judges. For the most part, we're leaving the state courts behind, and we're going to be focusing just on the federal judges. Clearly, you know the president can appoint the president, but they will be or must be confirmed by the Senate. I've got a little video for you that I'd like to show, and it's kind of interesting.
For a little inside analysis on the Elena Kagan hearings, we're joined by Marcia Coyle here on the steps of the Supreme Court. Thanks for your time today.
Happy to be here, Harry.
So in terms of the nomination process, what are some of the key moments that have gotten us to where we are today?
Probably people would be surprised to learn, Harry, that judicial nominees did not appear before the Senate Judiciary Committee until the late 1950s. That's when we started having them appear and have public hearings. I would say probably the nomination of Robert Bork was the major turning point in how we have hearings today for a number of reasons. He became quite controversial because of the position he took on how he interprets the Constitution, which he felt went back to the original intent of the framers. And when he did that, he didn't find a right to privacy in the Constitution. And this ignited a lot of debate and discussion outside of the judiciary hearing room. We also saw with his nomination an intensification and intensifying a special interest group involvement in confirmation hearings. I believe it was 17 special interest groups that came to the Senate Judiciary Committee and testified against Robert Bork. And that was only inside the hearing. Outside of the hearing, there were television ads, special interest newsletters. It just generated a firestorm of controversy, his nomination.
Ted Kennedy weighed in as well.
Senator Ted Kennedy led the fight against his confirmation and had a very well-known speech in which he described Robert Bork's America.
In Robert Bork's America, there is no room at the end for blacks and no place in the Constitution for women. And in our America, there should be no seat on the Supreme Court for Robert Bork.
Of course, Bork was defeated by the Senate, and his supporters, Republicans, conservatives, coined the term "you've been borked" in the future. If a judicial nominee of any court faced opposition, there was this concern that he'd be borked by the liberals in the Senate.
So post-Bork is when it's become a much more politicized process?
I think it was much more politicized, but also I think it was a warning shot to presidents that if they picked someone who had a paper trail or was the least bit controversial, they would find that they were facing a battle in the Senate. So we started after Bork with a series of nominees who really didn't have much of a paper trail. There were one or two exceptions, but when they got to the Senate Judiciary Committee, not that much was known about where they stood on particularly controversial legal questions that would face the Supreme Court.
When we look back at Sandra Day O'Connor's testimony, she was remarkably candid, especially about abortion.
I would like to state, first of all,
I think she was surprisingly candid about abortion when she revealed how she personally felt about abortion.
my own view in the area of abortion is that I am opposed to it as a matter of birth control or otherwise.
But that she would faithfully apply the precedents on abortion that the court had issued. But I don't think she went too far in terms of other issues. I think Bork was probably the most revealing. And then after Bork, the nominees were well schooled in saying that they couldn't comment on particular issues because those issues might come before the Supreme Court.
I have to accept, because it is precedent, that as precedent, and so I can't comment further than to say that I understand the questions.
But in this day and age, would it even be possible for a Sotomayor to have made it through the confirmation hearings had she said, here's my view on abortion?
I think it would have been very difficult. We know how controversial and divisive abortion is. And I think probably some members of the committee have a sense of where these nominees may stand on the abortion question. But you're not going to get a nominee to come out and say, I would reverse Roe versus Wade or any of the other Supreme Court precedents. They're going to pledge allegiance to what we call stare decisis, which is standing by the precedents of the court.
I have not got any agenda on what should be done with Roe v. Wade if that case were brought before me. I will listen to both sides of that case. I have not made up my mind.
How did the Clarence Thomas hearings change the tenor of hearings forever?
In 1981, I was introduced to now Judge Thomas by a mutual friend.
The Thomas hearings sort of upped the ante on partisan politics. It was an anomaly in a sense that we don't often hear senators questioning nominees for the Supreme Court about their personal lives. But with Thomas, there was a charge of sexual harassment, and it was something that reflected on his character, which is an important issue for senators in judging whether they should confirm a nominee. But it became a very bitter sort of confirmation.
There is nothing this committee, this body, or this country can do to give me my good name back. Nothing. I will not provide the rope for my own lynching or for further humiliation.
So was that the sort of watershed moment? From there onward, we've seen really a left versus right, nominee versus confirmation, in the sense that we have senators who are supportive automatically throwing softballs out, and senators who are ideologically opposed just hammering the witness.
I think Bork was the watershed. I think, as I said, that Thomas upped the ante, but also was something of an anomaly. I think the senators who have share the same political party that the president does will want to support the president's nominee. Today, everything seems more highly partisan, so I don't think you can just blame Supreme Court confirmations for that. We see it on just about every issue. So do the American people see it on just about every issue that goes into the halls across the street.
But did the hearings become more personal? Did we redefine what we could start asking people about?
I don't think the ground rules have changed. I'll be very surprised if senators ask Elena Kagan if she's gay. I think that issue has come up, but it's come up because of special interest groups that are involved in this confirmation process. I think Senator Leahy, who chairs the Judiciary Committee, has said that he would rule that type of question out of order.
Marcia Coyle with the National Law Journal, thanks so much for your time.
My pleasure.
Okay, I thought it was kind of interesting, kind of gives some background on the appointment process, but let's continue. Once we see here, we cannot forget this, judges serve for life, unless they're impeached, of course. Kind of keeps them out of the election process, trying to serve the citizens. They always would have to keep that in mind, what the citizens would want, what the voters would want. That kind of gives them a break, and can make the decisions based on what they think is right and wrong, not on trying to be reelected, which is why they serve for life. And finally, we can talk about this very briefly. Sorry about that. I want to bring up how much the justices make. And the Chief Justice makes about $217,000. That's John Roberts, of course. And the Associate Supreme Court Justices, the other 8, make about $208,000. Again, a lot of money, kill for that kind of money, but to make that in a year. But in the end, these guys are the top lawyers around. And if they worked at a New York or Washington, D.C. law firm, they'd be bringing in 6, 7 figures every year. So again, serving the government, you do at a pay cut. This is just the first PowerPoint. Went a little long because of the video. I apologize for that, but again, it's just the meat and potatoes. We'll talk more in the second part on the actual 3-court system and how a court case goes through them.